Thanks for joining us for the Member xCite presentation. The Member xCite presentation is informative, interesting to the audience, and showcases the strengths of the presenter as an entrepreneur and their area of expertise. It's not a sales pitch, it's a 10-minute educational and insightful exploration into what they do. And of course, it's exciting.
Ladies and gentlemen, please welcome our xCite presenter today, Luke Shanahan from Shanahan Family Law, to present to us on settling family law disputes amicably. Most people hopefully won't need to learn the intricacies of family law in your lifetimes, but it is perhaps useful to know some of the basics in case a friend or family member goes through a separation with his or her spouse. Luke Shanahan is a trusted and results-orientated family law expert on the Sunshine Coast who helps people get through their challenges in a timely and dignified manner. Ladies and gentlemen, please put your hands together for it. Luke Shanahan.
So as you all know, Luke from Shanahan Family Law, I opened up my practice nearly 5 years ago now, practicing in all facets of family law. I wanted to speak today really just to give you a bit of an educational piece about the nuts and bolts of family law. And I think it's probably good to start by saying that under the umbrella of family law, there's probably 5 areas that you could say deeply fit underneath the umbrella. There's child support. We don't do a lot of child support issues because it's heavily governed by the Child Support Agency, so it's sort of a domain these days without too much involvement from lawyers. But every now and then there's an appeal of a decision that goes through to the Administrative Appeals Tribunal of a decision made by the Child Support Agency, so lawyers have a role in that regard. But other than that, probably very little. We give some general advice to clients when they first come in to see us to say, these are things you can do, these are things that the CSA, the Child Support Agency, generally will do. And there's an online calculator that the CSA provides, so that's probably the best thing that we can do to help our clients is to put them in touch with this online estimator. They can punch in their factual data, and then they get spat out an estimate as to how much child support they'll be entitled to or have to pay. That's generally good for people who are considering going into a binding child support agreement and or have been proposed by their ex-partner to go into one. That really locks them into an amount that they have to pay. And before they go and do that, they generally, if they're the payer, they want to jump onto the online estimator just to make sure that the amount that's being proposed under the binding agreement is in fact less than what they'd be obliged to pay through the Child Support Agency, because they don't want to bind themselves to a higher amount if they're the payer, and the reverse for the payee. You might think, why would a payer bind themselves to an agreement? It may be that they are aware of or are planning to change their factual circumstances. Their income might go up in the near future. Their ex-spouse may not know their income is about to go up. They might be offered a job promotion with more money, or they might be taking another role with more money, and they really want to lock in that child support rate before they jump to a new role with more money and then be assessed with paying a higher amount. You can debate the ethics about that, but that's what happens on a daily basis. The second area is domestic violence, under the 5 broad areas of family law. We do, I don't personally, but the lawyers in my practicing family law, domestic violence applications and defending those. One thing I think we have found since COVID is that there's been a lot more domestic violence, unfortunately. There's been lockdowns and financial strain put on relationships, and also we found fly in, fly out workers too at the commencement were having a new dynamic thrown into the relationship where they would ordinarily spend quality time together, and then all of a sudden they're spending quantity of time together. And their relationship, we found, not all of them obviously, but a lot of them, they didn't know how to adjust to that new dynamic. And we were getting a lot of people that were in a relationship with fly in, fly out worker, or were the person going in and out to the mines, or wherever it was. So that was an interesting little anecdote that we found. And as I say, regrettably, domestic violence numbers shot through the roof once COVID lockdown started to be introduced. So we do all of that sort of thing as well. The third one we do quite a bit of as well is just the divorce application. A lot of people think that the phrase divorce application means dividing up the property or making arrangements in relation to the time that the children spend with each parent, but it's actually just the certificate from the court that says you're no longer married anymore. So we do those. They're fairly straightforward, and since COVID, a lot of them have been done just by telephone. So it's a very quick and simple process where the parties, usually without the assistance of a lawyer, we usually do the application up for them because they find it's easier for us to do that. But in terms of the appearance, we generally tell them it's not a difficult appearance, and there's no point paying us an hourly rate to go and sit on the phone to tell them the court registrar the factual circumstances, and then it's and then the divorce order is issued. I did appear on a contested one the other day, but that was because the party and the lawyer on the other side didn't understand how easy it was to get a divorce application, and they were objecting to the divorce application without any basis for doing so. So I had to appear on that one, but most of the time it's just the parties who just appear on the phone together. And the next two are really our bread and butter. This is where we practice predominantly on a daily basis, is parenting disputes and property, parenting disputes and agreements, and property disputes and agreements as well. So that's parties coming to us with either an agreement that they've already reached with their spouse and they want to formalise that agreement, and they can, obviously there's a lot of people out there who don't even come and see a lawyer, and they have a handshake deal, which is fine with parenting. There's no problem at all with that. With property, it's fine as well. My parents separated, and they had a handshake deal in terms of dividing up the assets, and there was never any issues concerning that. But what it does, we tell clients, what it does expose you to potentially is the risk that after that handshake deal has been completed and money has changed hands, it may be that one of the parties decides to go off to court and say, I want enough bite of the cherry. And there's nothing to stop them from doing that. So we say there's two primary reasons to finalise your property agreement formally. That is A, so you've got a fully final property settlement, and there's no coming back later on for another bite of the cherry. And B, if there's a transfer of property from one party to the other, say family homes that has two names on the title and they want to transfer the title into one name only, there's transfer duty that would ordinarily be payable if you just had a handshake deal and you went off to the Office of State Revenue to get that transaction assessed for duty. Having your property settlement formalised provides you with a waiver or exemption of the transfer duty, and so that you might spend a few $1,000s on formalising your agreement, but then end up saving $10,000, for example, on transfer duty that you might ordinarily have to pay on one transfer. If you've got multiple properties, then it gets higher and higher. I'll talk just very briefly about parenting as well. Hopefully no one in this room will have to ever use this knowledge, but it's good to be able to tell friends and family members, I think, a general gist of how it all works. So if parents have separated and there's a dispute between them about where the child is to live or children and how much time is to be spent with each parent, then the overarching principle that the court will govern the matter by is to say, firstly, there's a presumption that there's equal shared parental responsibility. So both parents have an opportunity to be involved with the decision making in relation to the children's major long-term issues. So children's education, religious beliefs, health decisions, all of those sorts of important major long-term decisions have to be shared equally. There's a presumption at least. You have to go to court to displace that presumption and get an order if there's one parent who's seeking sole parental responsibility to make all of those decisions. And that often does occur sometimes where the relationship is broken down so badly that these people can't talk to each other rationally anymore. And every time the husband sends an email off to the wife about Johnny's new school arrangement next year, it ends up in a barrage of abuse in an email. And so the mother in that scenario would go up to the judge and say, look at all of this, Your Honour. Clearly we can't co-parent together. All I get is a spray of abuse every time we try to raise these issues. And so in those circumstances, the judge may consider making an order for sole parental responsibility. So the mother alone can make those decisions without having to consult the father. There's also a formula in the legislation to determine who the child or children live with as well and spend time with. And again, there's a presumption that there is equal time, and if there's not equal time, substantial or significant time with the non-primary parent. And that's determined by this overarching principle of what is in the child's best interest, the children's best interest. So determining that requires a consideration of a multitude of factors, including when the child gets of sufficient maturity, usually around 13, although there's no set age. That's one of the features, amongst a raft of other considerations, including whether there's a risk of harm or abuse to the child or children, where being in the care for one or both of the parents, and if so, whether that time spent with that abusive parent needs to be supervised as well, either through a contact centre or the family member. So that's really just a general overview, as quickly as I can, about the 5 main areas of family law, and I hope you enjoyed it all.